Yeah.
Right.
Okay.
Very good.
Kate?
Next we have Sarah.
My name is Sarah, and I was wondering, if a person is charged with operating a vehicle under the influence of alcohol and driving with a prohibited blood alcohol content, can they be charged with 2 OVIs out of the same stop?
Okay. Actually, Sarah, that's a good question as well. And the answer is yes. Now, let me explain that a little bit. You're talking about operating a vehicle under the influence of alcohol and operating a vehicle with a prohibited blood alcohol concentration. Okay, those are 2 separate charges. They have distinct elements. Okay, so you can be charged with both, you can be tried on for both, and you can be convicted for both because they have different elements. One is driving with a prohibited blood alcohol concentration merely means that you were driving an automobile and you consumed alcohol so that you would test above a .08.
Okay.
That's it. There's no effect required.
Just have to test
You
above.
test over .08, that's a violation of
That's
Ohio
it.
law. The other one is driving under the influence, and that is the police would have to show that you operate a vehicle, consumed some alcohol. Again, it doesn't matter how much, but the alcohol you consumed impaired your ability to drive an automobile. So it's like an effect.
Yeah.
So that's why they're different charges. However, in Ohio, while you can be charged with both, convicted of both, you may only be sentenced on one. They merge for sentencing.
I see.
Okay, so if they occurred out of the same incident. So you can be cited for 2, charged with 2, but they merge and you only get sentenced on one.
I see.
So that's a good question because it's a hard concept to understand.
So, Judge, on that one, on the impairment, though, so it's possible then to be convicted for the crime without actually exceeding the...
Well, yeah, because in fact the way the law is on driving under the influence of alcohol, there is no test, and a test is not even relevant to that charge. So oftentimes, if you refuse to take the test, they don't charge with BAC. They have nothing, so they charge with driving under the influence. Or if they don't ask you to take it, or if the machine isn't working, they can still charge you. Or technically, I suppose, if you test a .075 or a .07 under it, if they feel that your driving was so impaired by the alcohol, they can still try you and get convictions for operating a vehicle under the influence of alcohol.
It's, we always equate it to, the magic test number. If you don't,
yes,
but that's not necessarily
That's not necessarily true. And I should also preface this and when I say alcohol, by the law, it's alcohol and or drugs of abuse.
Right.
So we do have those charged with driving under the influence of drugs of abuse.
Okay.
And drugs of abuse, by definition, can be prescription drugs if you abuse
you mentioned that on
the
Law Talk.
regular
Good point.
what the prescription is. So some people, whether it's narcotics or just marijuana or higher substances, that can be a violation instead of alcohol. It's the same penalty, same case.
Boy, Kate, you're on a roll as far as these soon-to-be or new drivers coming up with these questions.
Yeah, they're good questions.
Yeah, they really are. What else you got there?
Okay, so next I have Amber.
Hi, my name is Amber Summer, and my question is, if asked, should someone take a breath test?
That's a very good question. It's a very common question. A lot of people want to know that. Let me preface this by saying I'm not allowed to give legal advice. So I can't tell, as a judge, I can't tell you what to do. However, I can tell you that there are consequences of what the ramifications are for this. So in Ohio, we have what we call the implied consent law. That just means that by virtue of you obtaining a driver's license and being given the right or the privilege to drive in the streets, because as you know, you don't have a right to drive. It is a privilege granted by the state of Ohio, so therefore they can limit it. By the implied consent law simply means by virtue of you obtaining a license, you've already given your consent to take a test if you're asked by law enforcement. Okay, that's why if you don't, they can penalize you.
Okay.
Now, so if you do not take the breathalyzer, well, if you take the breathalyzer and you test under a .08, the concept is you may not be cited and you're on your way. If you take the test and you test over a .08, odds are you're going to be charged with an OVI, immediate license suspension. You have to go to court. If you refuse, here's the penalties. If you refuse to take the test, it's an automatic 1-year license suspension. Okay? And that is in effect even if you are later found not guilty of the OVI. That 1-year suspension is simply because you refuse to take the test.
I didn't know that part, Judge.
Yes,
so
yes, 1 year.
Go through the process. You're not convicted on it, but you still lost your license for a year by the total.
Simply refusing. And on that charge, if you refuse, you may not get work driving privilege for a minimum of 30 days. Okay?
Wow.
So it's going to be a month with no privileges. Okay?
Okay.
Also, some places like Wadsworth, our prosecutor, if you refuse to take the test and then you apply for driving privileges after the 30 days, they oppose it. So therefore, we have to set it for a hearing,
I see.
and then we'll determine, and then I have to determine what's the hardship and whether or not I give you. Now, in Wadsworth and Medina County, I realize we don't have public transportation. So I'm pretty liberal about giving people the right to drive to and from work, okay, and job-related driving. But it takes a little longer because the state opposes it, and there may be some other restrictions. Also, if you refuse to take the test and you've had a prior DUI within the last 20 years, that's a new charge. So again, if you refuse and you've had a prior DUI conviction within the last 20 years, then that's what we call a state OVI. And that one, the charge is that you were arrested for OVI. You've had a prior OVI conviction and you refuse to take the test. So stop and think. If you go to trial, normally a jury's never going to hear that you have prior offenses.
20 years.
Because you don't want you don't want someone to convict someone from an OVI just because they've done it before. But in this case, not only does the state get to tell the jury there's a prior, they have to.
I see.
So your whole record comes in. So if you've had prior OVIs and you refuse, that's an element of the offense. And that's going to be,
Good point.
it's going to be very tough to beat that. Now, can people say, well, if you don't take the test, then that's less evidence in a trial. And that's true. But I've also found in Wadsworth, just over the last few years, juries do not like refusals. Because you talk after a trial, you talk to the jury.
Sure.
And you say, well, the juries come back and say, they were hiding something.
Right.
The fact that they knew that whether or not they were drinking.
I see.
And if they refuse to take the test, they think they're hiding something. And majority of those get convicted.
Yeah.
I mean, you'd think might not, but
Just by the pure
it's
refusal.
happened. Yes.
Well, Sarah raised a pretty good question. That was Sarah's question?
That was Amber.
Pardon me?
That's Amber.
Amber, I'm sorry. Well, Amber, let's seize the opportunity right now. What you're doing is going through the appropriate training to get a driver's license, which will give you the privilege to drive a car on public highways. What the judge raised for you and all your classmates is very significant. When you get that driver's license, you will be giving this implied consent, which goes right back to, you've already given your consent to take this test by the token of you're going to be a driver. So that's probably well worth keeping in mind to this. Another point, while I'm here, for the benefit of all our viewers, but especially our questioners who are soon-to-be drivers, those of you who are not 18 years of age, and we know when you meet the judge you would be pleased to meet him, as we all are. But the judge works in Wadsworth Municipal Court. Their jurisdiction is for adults 18 and over. So these issues we're talking about, he personally has jurisdiction in Wadsworth Municipal Court. However, Judge, a youthful driver, somebody not 18 years old, the law is the same.
The law is the same, but the charge would be a little different.
Okay.
It's
going to be a different court too, right?
Different court, different charge, but the search, the refusals, those are standard.
Okay, so everything
So the penalties could be a little modified, and what the court's going to do be a little modified, but this is basic law in Ohio.
So somebody who hasn't reached, our drivers usually start somewhere around 16. For those young folks that haven't got to 18, Judge, where are they going? Which court?
Juvenile court. Medina County Juvenile
So
Court.
that would be Judge.
And you're perfectly right. The implied consent law applies to them as
Okay.
well.
So
Same
the
thing.
judge here in Medina County they would see would be Judge Lone.
That's correct.
Okay. Okay. Well, all excellent questions. Just a matter of how old you are. You'll all get to 18 before you know it. And, okay, and we hope you don't meet the judge under these circumstances. Kate, got another one?
Yes. Next is Cole.
It's Cole, and I go to Wadsworth, and I'm wondering, will you go to jail if you get convicted of an OVI?
Well, the answer to that is yes and no. Don't you love those kind of answers? Yes or no?
The law.
The reason I say that because under the law, there's mandatory jail for an OVI. On a first offense, it's a mandatory minimum 3 days, maximum 180 days. On a second offense within 6 years, there's a mandatory minimum 10 days in jail. On a third offense within 6 years, there's a mandatory minimum 30 days jail. After that, looking at felonies. Okay? So when I say those are mandatory minimum jail, that's what you have to do. But when I said no is because on a first offense, you can also do the DIP, or that's a driver intervention program. Some people refer to it as the 72-hour program. What you're allowed to do on a first offense, instead of going to jail for 3 days, you can do that program. Now, that program is actually held, it takes 3 days. But normally it's held in a hotel. It's an education process. You get counseling, you watch films, you have group discussions, you find out about the dangers of drinking and driving.
Excuse me, Judge, but it is mandatory. You don't come and go to that motel.
No,
you're going to stay there.
You're there. You're there for 3 days.
I see.
So instead of being locked up, you're in a hotel room.
I see.
In a hotel setting.
I think there's
you pay for that.
I was going to say there's a cost associated with this.
But
the county might put you up for 3 days, but under this
or you
one,
pay to have
you'll
the other.
pay. Okay.
And I think the law says that since the educational process is so worthwhile, and the hope is that if you take that class, you're not going to reoffend.
Sure, absolutely.
It's worth it. But you basically only get to do that once, okay? And it's only 3-day credit. But if you have a second offense, third, you got to do this. And when I say it's 3, 10, 30, days, those are consecutive days. They're not. You can't do it on weekends. You can't. You can't say, I'll come this week, take a week.
Sure.
And normally no work release. You're locked up for 3 days, and that's
in jail.
24 hours a day. Yeah.
I see. Well, that's
Very interesting.
good question there.
Yes. Okay. McKay would like to know.
Hi, I'm McKay. My question is, can an OVI charge be changed to a reckless driving charge?
Okay. Well, legally, if he says, McKay says, can it be? Well, yes. Legally, an OVI charge may be reduced to a reckless operation. What they're talking about is plea bargaining. Now, plea bargaining is used and occurs in every court in the nation. And it's just an opportunity to avoid the crowded dockets.
Sure.
But what that is that's where the prosecuting attorney and the defense attorney get together and plea bargain the case and say, okay, I'll reduce it to this if you plead to this.
Okay.
The court and the judge does not take part in that. Okay? However, the judge can either accept or reject a plea bargain. Okay? So while, yes, a OVI charge can be reduced, most courts anymore don't allow that. In the Wadsworth Municipal Court, I have a policy that there is no plea bargaining on OVIs. So OVIs in Wadsworth will not be reduced to reckless operation.
Well, there's a very clear answer on that one.
Right.
Well, Judge, I can't believe how fast the time went by. We always enjoy having you on the show. This time Ask the Judge, last time Law Talk, and we hope you come back again. To our new drivers or soon-to-be new drivers, we thank you for your show, for your questions, and for tuning into our show. I am John Celebrezzi, and I'd like to invite you again to view this episode, our second episode of Ask the Judge at our website, which is www.czclep.org.
Comments made by John's guest on Ask the Judge are solely those of his guest and do not necessarily reflect those views of Celebrezzi Zengi Community Legal Education Project, Inc. To view this show and others, go to www.czclep.org. Special thanks to Kate Feeks, CZ Klep's court reporter. And Judge Stephen B. McIlvaine. If you have any questions for Ask the Judge, please email us at john@czclep.org.